Good afternoon. Bonsoir. Bienvenue à l'Université d'Alicante. Welcome you all to the University of Alicante. We are going to start the opening session of this meeting entitled Intellectual Property in Europe, Same Rules, Different Practices. And in order to start with this opening session, I'm going to give the floor to the doyen of the Faculté de Droit de l'Université de Lille, Professor Jean-Gabriel Contamine. I think he is online.
Ladies and gentlemen, dear colleagues, dear friends, dear Edith, dear Caroline, I want first of all, as Dean of the Faculty of Law of Lille, share with you both my regret for not being able to be with you and enjoying the Alcanson, but also my thanks for allowing me to participate in introducing this conference about intellectual property in Europe, same rules, different practices, co-organized by the Private Law Applied Research Team of the University of Lille and by the Magister Luz and Tinus of the University of Alicante as part of the International Research Lab, LAC+. I have a specific pleasure in introducing this conference as Dean of Faculty of Law, which welcomes around 8,500 students and which gives an important place to intellectual property law, both in its training and in its research. Indeed, there's an increasing emphasis today on the need to combine the research dimension and the training dimension and to develop the internationalization of our university and of our faculty. Today's conference is a fine example of the successful combinations between those different dimensions. Indeed, Edith Blary was the creator with Michel Dupuy of the University Diploma of Lille in Industrial Property Law and New Technologies, at the time the first in France, an innovative training which can now be followed by both in person and through distance learning. Edith has also directed for many years the Master 2 in Industrial Property Law, the direction of which she entrusted to Caroline Le Goffic, ensuring what is important and what is difficult, as successions and the continuation of this fine legacy for our faculty. Indeed, the development of those training courses is also linked to the development of a real research program around intellectual property law in Lille, with a specific interests on the question of the harmonization or non-harmonization of legislations on cause laws in Europe. This focus resulted in several conferences around those thematics. A conference in 2005 on the patentability of biotechnological invention, a conference in 2009 on industrial property towards harmonization of European and internal case law, and a conference in 2020 about the question of harmonizations or non-harmonizations of law applied to specific objects design. The conference of these 2 days is, of course, in direct line with these previous events, which resulted in many publications. Furthermore, both in those research activities and in those training activities, a large place has been given to internationalization. It results in the development of strong links with the University of Alicante, which resulted in the establishment of an associated international laboratory, in numerous teaching mobilities, in joint research projects, and therefore in the co-organization of the conference. It also results in the development of strong links with the European Union Intellectual Property Office for the benefit of our students who can thus each year follow an international law seminar about trademarks in the European Union in partnerships with the Master about Industrial and Intellectual Property of the University of Alicante. I'm often asked as Dean to try to define how our Faculty of Law differs from other faculties of law in France and in Europe. We explain in which specialty it excels compared to others. In this case, as the example I've just quoted proves it, I can easily argue that intellectual property law is one of these specialties, precisely by this perfect combination between the research dimension and the teaching dimension. A perfect articulation which is also reflected in the perfect combination in the program of this conference between academic personalities and eminent representatives of the professions and authorities linked to the world of intellectual property. This speciality makes also perfect sense given the situation of the city of Lille itself, a city which is indeed a major place for intellectual property in France and Europe, a city which is characterized by a strong industrial fabric, by the large number of companies exploiting intangible resources, a city which is also characterized by the presence of the Observatory of the National Institute of Industrial Property, and finally a city which is characterized by the proximity to other European capitals, which fosters strategic discussions on intellectual property rights and makes the problem of the harmonizations of legislations and of the obstacles to these harmonizations really important. All this therefore explains the pleasure I have in taking part to this conference introductions, even if I would of course have preferred to be able to do it in person. Finally, I want, from the Lille point of view, specifically congratulate Caroline and Edith for the organization of this event, and thank Edith for her investment throughout these years, which has contributed to make the University of Lille and our faculty an important place for research and training around intellectual property law. And finally, I want to wish you all fruitful discussions in the next 2 days. Thank you for your attention.
Thank you very much, Dean of Lille Faculty of Law. Thank you for these nice and enthusiastic words. Now I'm going to give the floor to Professor Pilar Montero. She is the director of the Magister Lucentinus Master on Intellectual Property and Digital Innovation at the University of Alicante, probably one of the most prestigious master programs in our institution. The floor is yours.
Thank you so much. Thank you, Vice President of International Relations of the University of Alicante. I would like to start with really my real grateful for this seminar. I would like to explain a little bit why we are organizing this seminar. The content of the seminar will be explained later by Professor Edith Blary, but I would like to highlight that this seminar is an expression of the long-standing relationship we have between the University of Lille and particularly the LERAD, the department of the University of Lille, and the Commercial Law Department of the University of Alicante, because we have for now, I think more or less for 20 years, we are collaborating particularly in IP rights and also in other important topics regarding commercial law and business law. I think these seminars represent a big step in our research because it's the development of a very important seminar or department. We have a bilateral department between Lille and Alicante, and it's for that reason that particularly the topic of this seminar, as we can see in the title, Intellectual Property, Same Rule, Different Practice, highlight the importance of having a research in intellectual property rights, particularly inside the European Union, in order to have a better framework on intellectual property in the future. For this reason, I would like also to highlight and to thank all the different collaborators we have had in this seminar. First of all, for sure, I need to thank the University of Lille, the LERAD, and particularly Madame Edith Blary, Professor Blary, and Professor Caroline Legofic, also Anaïs Depinois, and all the team of the Faculty of Lille, because it has been a very important effort in the organization of this seminar. And of course, I need to thank all the different collaborators and particularly the scientific committee. And in this regard, I would like to thank, first of all, the Professor Esperanza Gallego, the director of our department, also Nuria Fernandez, professor and director of this seminar, and also the different speakers we will have in this seminar, also colleagues from the commercial law department and the different professors organizing the seminars. Also, a big thanks to the different institutions, some present today and others will be here tomorrow, collaborating with us in these seminars. And particularly, let me thank Irene Madero from the French Competition Authority, also Francisco Ripoll from the Spanish Authority of Competition. Thank you so much also to the CEIPI for the speakers we will have from this institution. Thank you also to the University of Rennes. Thank you to Novagraph. We will have Aurélie Guetin from Novagraph. I would like to thank also the different offices, and in this regard, particularly the CPBO, and also their president, Francesco Mattina, who will be with us today. I think in this seminar it will be also very important the different offices, intellectual property offices we will see with Francesco Mattina and the CPBO, but also I would like to particularly thank the EPO, the European Patent Office, or the president, and also the representative we will have from this office, the EIPO, we will see also tomorrow, all the different convergence programs regarding the intellectual property rights, patents and trademark in each one of the offices, the Spanish Trademark and Patent Office, always supporting the different activities of the Magister Rucentinus. Also, the intellectual property section of the National Police of Spain. I think it represents also a very big asset for us to know from them the importance of the counterfeiting and the conversion practices in the real life. I would like to thank also the University of Castilla-La Mancha and the University of Rennes, I think. So even if we have lots of collaborators, and I think I thanks all of them, and Vincent Mason, sorry, I think it's important because it's because of them we have the possibility to really have a very important overview regarding the different practice we have, particularly in France and Spain, but also we will see in other countries, and perhaps learn between each other the best ways and the best route to build an important and strong intellectual property framework for the different countries and particularly for Europe. So thank you so much to all of you, also to all the attendants and particularly students from the Magister Lucentinus, students from the University of Lille who are online. I hope you will enjoy the seminar and all of us will learn a lot from this project. Thank you so much.
Thank you very much, Pilar. Just to finish this opening session, I would like to share a few minutes with you all. And in first place, I would like to congratulate all the organizers involved in this nice conference. The doyen de la Faculté de Droit de Lille, Professor Jean-Gabriel Contamine, the director of the Commercial Law Department at the University of Alicante, Professor Esperanza Gallego, the director of our Master Lucentinus, dear Pilar, all the organizing committee members, the academic authorities here in the audience, researchers, students, ladies and gentlemen, Monsieur, Madame, once again, welcome you all to the University of Alicante. Bienvenue to our university. C'est un plaisir pour moi d'être ici aujourd'hui avec vous, tous représentant l'Université d'Alicante par délégation de notre directeur, professeur Amparo Navarro Faure. Je continuerai en anglais parce que c'est la langue choisie pour la réunion. Excusez-moi. With my first words, I would like to thank the organizers for giving me the chance to be here today on behalf of the University of Alicante as Vice President for International Relations and Development Cooperation. For me, it's a great honor and a privilege to welcome you all to this international meeting, mainly a bilateral meeting between colleagues from France and from Spain. And really nice and outstanding conference focused on intellectual property and digital innovation and other closely related fields. To all of those following the conference by streaming, welcome too. As you may know, the University of Alicante is probably one of the youngest universities in the southeast of Spain. As you can see, the campus right now is only 44 years old, but in fact the origin of the university dates back to the 19th century. It is a comprehensive university in which almost all fields of knowledge are covered, and in terms of ranking, what we could say right now is that our institution is very well reputed and occupies outstanding positions in the most popular rankings, global rankings. Because of that, currently the University of Alicante is an international campus with around 3,800 academic and administrative staff, over 35,000 students, enroll in different official degree programs, master programs, PhD programs, and thanks to this internationalization and our bilateral agreements, each year we are able to host around 2,000 students coming from other Spanish regions and around 1,500 students coming from other countries. So it's a huge number of people coming from abroad each year. Regarding to the specific topic of this conference, I would like to highlight that our institution is a reference in Spain in that field of knowledge, in the field of the intellectual property and digital innovation, for several reasons that I'm going to summarize briefly. First of all, a significant number of Spanish professionals working in this area have been trained in this master. In second place, Alicante, as a whole county, offers a privileged ecosystem for collaboration on intellectual property and digital innovation, because as most of you may know, some institutions like the European Union Intellectual Property Office is located here in Alicante. So this is why we have created somehow a good environment to support studies and collaborations in this field. And last but not least, Alicante County has established itself as the great digital and artificial intelligence hub in the Spanish Mediterranean. This is another important issue to keep in mind in order to understand how relevant this field is here. In the context of this meeting, you will analyze how and why the same rules make possible different practices in terms of intellectual property management in Europe, paying special attention in France and Spain. I congratulate and appreciate the effort you made for this organization by including companies in the discussion. Why I'm highlighting this issue. We have to keep in mind that academics, researchers, and institutions cannot live with their backs to the societies and the companies around them. And this is why I think that this conference is a really nice example about how you combine and integrate not only the academy, not only the research, but also the companies and all the actors taking part of this field of knowledge. To finish my words, I would like to wish you all a successful conference, sharing knowledge, ideas, consolidating your collaboration, and looking for more new partners in order to carry out your research. I hope you find some free time to enjoy Alicante, because it's one of the most beautiful cities in the Mediterranean seaside. And why not enjoy the climate, the beach, and our gastronomy. Thank you very much, and all the best for your research. And with this, the conference is open.
Ladies and
So now we will have the pleasure to have the first conference by Madame Professor Edith Blary-Clément, the director of the laboratory we are now developing with this seminar. So thank you so much, Professor Blary, for being here for this seminar, and you have the floor.
Merci. Madame la vice-présidente, elle est partie, mais c'était prévu. Monsieur le doyen, il n'est pas là non plus. Chers collègues, mesdames, messieurs, il m'a été confié la charge d'introduire les travaux de ce colloque et j'en suis très honorée. Mais avant toute chose, comme il se convient, je voudrais remercier l'ensemble des personnes qui ont contribué à la tenue de cette manifestation. Manifestation, nous l'avons dit déjà, qui s'inscrit dans le cadre du LAI Lac Plus, que j'ai créé avec mon ami Pilar Montero, pour renforcer notre coopération entre nos équipes de recherche. C'était vraiment notre objectif, renforcer une coopération qui avait déjà commencé. Alors en français, vous l'avez entendu, le thème retenu est la propriété intellectuelle en Europe, convergence normative, divergence des pratiques. Le choix de ce terme part du constat que le droit de la propriété intellectuelle est un droit harmonisé au niveau européen, au niveau international. Convention de Paris, Convention de Berne, TRIPS en sont la preuve. Au niveau européen, règlements et directives ont contribué à la mise en place d'un droit de la propriété intellectuelle uniformisé. Les directives transposées rapprochent les législations nationales. Plus encore, la création de titres européens participe de l'uniformisation du droit. Dès le XIXe siècle, la nécessité d'une large coopération internationale s'est affirmée, permettant l'ancrage de la propriété intellectuelle dans le fonctionnement de l'économie industrielle. Depuis lors, elle n'a eu de cesse que de se développer. Si on peut se féliciter de ce mouvement, le constat d'une forte convergence normative ne doit pas occulter les divergences qui subsistent. Les causes de ces divergences sont identifiées: transposition non conforme, problèmes de traduction, interprétation des textes divergentes, jurisprudence antagoniste, pratique des offices aussi. Les effets sont connus. Les divergences nuisent à l'efficacité du système, elles entravent le bon fonctionnement du marché, elles sont source d'insécurité juridique. Des marges de progression existent toujours et il convient de chercher ces marges pour réduire les divergences. En matière de normes, de gros efforts peuvent être faits, en matière de droit d'auteur par exemple, nous le verrons. Si les avancées semblent plus significatives en droit de la propriété industrielle, elles restent pourtant insuffisantes. Les travaux de la Commission le montrent et la réforme en cours du droit des dessins et modèles l'illustre parfaitement. Il suffit de s'intéresser, comme nous le ferons, aux pièces détachées pour s'en convaincre, au régime des pièces détachées pour s'en convaincre. Les efforts doivent donc être poursuivis. Mais ils ne peuvent se limiter, ces efforts, au seul rapprochement des législations. Ils doivent porter aussi sur les pratiques des offices, des juges, des institutions, institutions par exemple qui interviennent pour assurer le respect des droits de propriété intellectuelle ou même pour la protection des consommateurs. De nombreux facteurs concourent, de nombreux facteurs de nombreux facteurs concourent donc à la réduction de ces divergences. Ils s'inscrivent dans le mouvement de consolidation du marché unique européen. Les droits de la propriété intellectuelle sont un atout essentiel pour l'Union européenne et la Commission l'a clairement rappelé, notamment dans sa communication du 25 novembre 2020. C'est pourquoi les débats qui vont suivre seront consacrés à cette nécessaire convergence, non seulement normative, mais aussi à la convergence des pratiques, sans laquelle la convergence des normes serait lettre morte. Ainsi, dans la première session de nos travaux, il sera donc question de ces facteurs de convergence. Ils sont économiques et découlent de la nécessité d'instaurer une saine concurrence au sein de l'Union. Il s'agit de lutter contre les pratiques anticoncurrentielles, que la mise en œuvre des monopoles d'exploitation générés donc par les droits de propriété industrielle favorise et que les disparités de législation accentuent. Loin de s'opposer les droits de propriété industrielle, intellectuelle et les droits de la concurrence se conjuguent pour atteindre des objectifs socio-économiques communs. Se mêlent aussi des considérations plus sociétales, liées à la sauvegarde de la santé publique. Il s'agit de préserver donc la santé publique sans freiner le développement de l'industrie pharmaceutique et les échanges de médicaments au sein de l'Europe. Les disparités des dispositions nationales ont une incidence directe sur le fonctionnement du marché du médicament. Le rôle des juridictions ici, et notamment de la JUB en matière de certificats complémentaires de protection, donc semblera essentiel. Plus récemment, ce sont des impératifs écologiques qui ont émergé. La préservation de l'environnement, passe aussi par les droits de propriété intellectuelle, qui sont donc des facteurs essentiels pour le développement et la diffusion des technologies durables et respectueuses de l'environnement. Ce sont, selon la Commission, je cite, des outils de création de stratégies collaboratives pour le partage de technologies dans les domaines écologiques et numériques et le développement donc des entreprises aux technologies vertes et numériques. Une fois les facteurs de convergence identifiés, notre deuxième session sera consacrée aux vecteurs de convergence, aux outils, aux actions pratiques qui favorisent sa mise en œuvre. Nous savons que le travail normatif est considérable, même s'il doit être poursuivi, nous l'avons déjà dit, et que la réforme en cours des dessins et modèles, après celle des marques, va clairement en ce sens. Mais les textes ne font pas tout. Il faut aligner leur interprétation. Des divergences de jurisprudence sont régulièrement dénoncées et les juridictions, notamment supranationales, s'emploient à les réduire. La mise en œuvre de principes, comme celui d'interprétation conforme, ou de quelques concepts comme celui de notion autonome dont il sera question lors de nos débats, facilite la convergence des interprétations et donc l'harmonisation du droit. Elle réduit la marge de manœuvre des juges nationaux. Dans cet esprit, il faut souligner le rôle unificateur de la CJUE, pour qui une notion autonome du droit de l'Union doit être interprétée et appliquée de façon uniforme. La création de la juridiction unifiée des brevets participe de ce même mouvement, cette cour supranationale ayant pour mission de constituer une jurisprudence européenne harmonisée en matière de brevets et de renforcer donc la sécurité juridique et de lutter par là même contre le forum shopping. Parallèlement, Parallèlement, les offices comme le UIPO, l'OEB, l'INPI pour la France et l'Office espagnol, mais aussi des institutions comme les douanes ou la police coopèrent. La création du réseau européen de la propriété intellectuelle permet la mise en œuvre de la coopération au sein de l'Union et l'harmonisation des pratiques. Cela passe, par exemple, on nous le dira, par des pratiques d'examen communes. Les programmes de convergence arrêtés au niveau européen sont des vecteurs essentiels de convergence, des vecteurs tout à fait efficaces pour atteindre cette convergence. Si les choses sont un peu différentes en matière de droit d'auteur, cela ne veut pas dire qu'il n'existe rien. Les initiatives des auteurs, notamment en matière, par exemple, d'intelligence artificielle, le prouvent, et nos collègues Stéphanie Lecam et Pilar Montero le montreront. Enfin, le débat ne se limite pas à la propriété intellectuelle. L'ensemble du droit des affaires est concerné par le mouvement de convergence et la nécessité de lutter donc contre les divergences des normes et des pratiques. Pour illustrer le propos, donc, deux intervenants nous parleront donc du droit des sociétés et de cette convergence donc en droit des sociétés. Mais d'autres exemples seraient possibles, ils seront sans doute la base de travaux futurs, qui restent encore très nombreux, me semble-t-il. Donc, après cette présentation très générale de notre programme donc pour ces 2 journées, je vous propose de passer dans le vif du sujet et d'aborder donc notre première table ronde qui sera modérée par Madame Anaïs Despinois, qui est maître de conférence à l'Université de Lille. Je vous remercie.
Thank you so much, Professor Blary. Now we will start with the first roundtable. Thank you.
Good afternoon, everyone. Where is Natalia? Is she connected already online?
I'm here.
You're here?
Yeah.
Fine, welcome. Good afternoon, everyone. Before we start this roundtable, I'd like to thank the organizers of the conference to enable me to moderate this roundtable. Thank you also to our dear Spanish colleagues for their warm welcome. The theme of this roundtable is competition law as a factor in the convergence of intellectual property standards. This is an assumption we have to verify, I think, and our speakers will help us to do so. Today, we are fortunate to welcome specialists in both competition law and intellectual property law in Spain and in France. First, Irene Modero, here on my left, comes to us from the French Competition Authority, and she's an expert in competition law. Welcome. We also welcome online Natalia Capirina. She is an associate member of CEPI, the CEPI Research Laboratory at the University of Strasbourg, and she is an expert in IP law, most specifically in design law. Welcome, Natalia.
Not competition law.
Not competition law, oh. Then Francisco Ripoll Vasquez is Chief Competition Inspector in the Information Society Subdirectorate at the National Markets and Competition Commission. And he is an expert in intellectual property, but much more, I think, in competition law.
Yeah, more in IP than in competition law.
Okay, and of course, Vicente Guimeno also shares this roundtable. He is professor at the University of Alicante, and he is an expert in commercial law, I think, and in industrial property law, isn't it? Fine. So together we will ask whether competition law is indeed or not a factor in the convergence of intellectual property standards, and if so, in what way? We know that intellectual property standards are largely harmonized across the European Union, but there are differences in the ways these standards are applied when they do. So we could search why and how competition law drives and supports this harmonization. We could also determine if competition law explains the divergences in practices and the application of harmonized standards. Before answering all these questions, I'd like to propose a reminder of the relationship between IP law and competition law. IP law is seen as a restriction on the system of free competition. In economic terms, intellectual property is intended to regulate competition. However, competition can also regulate monopolies that are too strong. But we have to say here that there is probably a kind of paradox between these areas, even if they are not incompatible. Thus, competition law makes the application of IP law effective, most effective. Irene and Francisco will help us to verify it with the example of the online publisher neighboring right from Google case. Competition law also regulates the consequences of a monopoly that is too strong so as to reintroduce freedom. That's what Natalia and Vicente will expose from the example of the repair clause concerning spare parts of complex products. Our speakers, of course, will present us the positions of Spain and France about this global topic, and it should lead, I hope, to compare the positions and practices of national legislations. Well, the first area we need to discuss concerns the neighboring right, Google and its supposed abuse of dominant position. The directive of April the 17th of 2019 on copyright and related rights in the digital single market has led member states to create a new neighboring right for online press publishers. The same year, France anticipated it by creating this right through the law of July the 24th. But I think that at the early 210, Spain already created such a right, as I remember Germany in 2013. Isn't it, Francisco?
Well, yeah, actually in 2015, a new kind of right protecting content of publishers entered into force in Spain through a modification of our copyright law. And it was a very specific regulation because it's actually established that content with a periodistic nature, not only limited to, I'm going to make like some contrast because they are different to the actual right. Content with a periodistic nature, not only new, strictly understood as news content, was afforded a kind of protection, a new. I mean, actually, it was like a modification of the limit of the use of that content was created, and an equitable remuneration was established for the holders or the creators of that content, or the editors in this case, which places this content online. And this content could be used without the permission of the right holders by the internet service providers that use them in a particular way. And what this regulation established actually was that anyone who wanted to use that particular content could pay to the collective management entity in charge of the management of this right, in this case it was Cedro, to use this content. And this collective management entity will set the price for the use of that content in the way that the internet service providers wanted to. And another of the particular notes of this particular right that was introduced was that the right was unwaivable by the editors. Editors could not could not give their consent to the internet service providers to use their content. They were obliged to license it in the way that this regulation established.
Thanks. So you just answered, I think, to my other question, which was how was it received, isn't it?
Well, actually, it was received with quite a wide criticism by all the sectors. I mean, it wasn't very popular in a way because it didn't limit itself, as I've stressed before, to strictly news content. It referred to periodistic in some way content, and it was believed that it could also cover blogs or other non-professional journalist web pages that could be also under the scope of this regulation. And this was seen like quite limiting the actual free movement of ideas and of liberty, of freedom of expression, in the internet. So this was very criticized for this reason, but also criticized by the sector that was trying to be protected by this regulation, because even the publishers, not all the publishers were happy with the fact that they couldn't have any control over their content. Their content had to be licensed compulsorily by the Cedro without them being able to say no, not to you, or no, not like this. I mean, it was some kind of compulsory license that was imposed to them, although they were earning money for that, but without any control over who used and how the content. And it was particularly criticized by the CMC itself. I mean, the Spanish Competition Authority issued a report regarding this modification in May 2014. It's online, and everybody interested in it can check it. And the criticism from the CMC was doublefold. First of all, criticized the actual need of this regulation and the opportunity of it being implemented. In this sense, there's a CMC motto, and I think it's shared with other competition authorities, that competition is the best solution to achieve the efficiency of the markets, and only when there's a market failure, regulation is needed. And in this case, it's not that clear a market failure was happening. It's not that clear that this regulation was needed to balance and to provide a fair balance to the situation that was being experienced. Furthermore, this situation created a new barriers of entry to new internet service providers that wanted to enter or provide the services that the previously to 2014 other internet service providers were providing, and had reached the quotas of users that made them strong in the market. So this was also criticized, and particularly from the actual way it was regulated, the CMC was very critical with the fact that a monopoly was granted to Cedro, to this collective managing entity, to offer or manage actually the market of neighboring rights, because he was the only that could set the price and offer or not offer or receive the money from the internet service providers. And the other part that was criticized was also this unwaivable nature of the right that made actually made a new kind of compulsory license, and that made Cedro establish like equal prices for all the publishers without taking into account the different nature or the different necessities of each publisher. So that was the main critique of the National Competition Authority. But it was not a very popular
Thank you very much for these confirmations and those explanations. Now, if you like, let's talk about the application of this right in France. In April 2020, the French Competition Authority found that Google refused to faithfully negotiate in the face of the new neighboring right legislation toward the neighboring rights owners. However, what we have to mention here is that Google wasn't abusing of its dominant position, even if they were suspicious. And Google's case here is mentioned because it's the most famous one example, but there are also other cases. So Irene, could you explain to us more precisely how Google's refuse was handled by the French authority, please?
Of course, thank you, Anaïs. As you mentioned, France was the first country to transpose the copyright directive that introduced the neighboring rights or ancillary rights. If I say ancillary, it's the same as neighboring rights. Only 3 months after its implementation. As you already explained, and Francisco also explained, the objective of the ancillary right is to remunerate the online use of digital service providers of press press content. A very important challenge for the publishers, at least in France, and the newspaper, is the use that is made by digital aggregators of small extracts of their publication. Because in many cases, the first results of Google research pages are press content. For example, let me give a very precise example. If you are in a dinner and you're talking about a news, for example, there are currently elections in Argentina, and you want to know who are the candidates to this election, you will probably take your phone and enter in a Google research page, elections in Argentina. The first results will be extracts from a newspaper. And if it's not the first result, you will probably look at the result given by a newspaper you know, El País or Le Monde, because you trust on this kind of source. And probably you won't even click into the link to visit the newspaper page, because the extract, what we call the snippet, will be enough for you to get the answer you're looking for. So the newspapers, the publishers in France, they wanted to be remunerated for that, because this information gives a lot of attractiveness to Google, because Google is able to aggregate this content, and it not always allows them to get the traffic from the Google newspaper. But the problem is that as soon as the French transposition law entered into force, Google updated its general conditions, deciding to stop to display any of these results unless it was given a free license by all the publishers. So the choice was very simple. Either the press publication gave a free license to Google, or they won't be shown in a Google research page. Of course, either publishers nor press agencies could afford to lose the traffic driven by Google through the Google research page. So 2 publishers' unions and 1 press agency came before the French Competition Authority, arguing that by doing so, Google was abusing of its dominant position and requiring for interim measures to be, or injunctions, to be pronounced by us. And that's the starting point of our neighboring rights saga in the French Competition Authority that already counts with 3 decisions. The first, that was mentioned by Anaïs, deals only with the interim measures request. So it doesn't, what you were saying, it's true that in this decision, the French Competition Authority never says that Google has abused of its dominant position, because it's a preliminary analysis of the situation in order to give a quick and effective solution to solve an ongoing problem, which was that Google didn't want to negotiate and didn't want to remunerate the ancillary rights to press publishers. So in this decision, the FCA considered that there was indeed a suspicion of an abuse of dominant position on 3 grounds. The first one was that Google was imposing unfair trading conditions. Second, Google was discriminating because it would give no remuneration independently of the quality, of the importance of the content that was published. And in a more original way, the FCA said that Google was circumventing the law, because the law, maybe that's a difference with the Spanish regime that Francisco presented, did allow publishers to give a free license. But it was an exception, and Google used this exception to refuse to remunerate any press publisher or press agency. So after finding this suspicion, the FCA considered that the conditions were renewed to impose injunctions on Google that were obliging Google to negotiate in good faith in view of formulating a financial proposals for the use of the protected content. And this decision was confirmed by the French Court of Appeal. The problem is that only a few months later, they came back, the press publishers and the press agency, saying that Google was violating the interim measures decision that we decided to allow. So Google wasn't negotiating in good faith. What was doing Google, what we consider that it was doing, is that Google was systematically driving the negotiations towards a license for a new service that it was going to publish a few months later, which is called Showcase. So instead of negotiating the current use that Google already did of the protected content, that is, for example, the snippets I explained at the beginning, they decided to negotiate a broad agreement, and by doing that, they weren't recognizing that the current use made by Google was actually covered by the directive and allowed for a remuneration. We also found that Google was reducing the scope of the ancillary rights and was reducing the the remuneration it was supposed to give for those rights. So we imposed a fine of 500 million euros and a penalty, a periodic penalty if Google didn't abide with the injunctions we pronounced. And finally, the case was closed for the moment on the merits by a decision of July 2022. Because the FCA could have continued the investigation in order to find a definitive or to decide whether there was a definitive abuse of dominant position or not. But instead of that, it decided to accept commitments undertaken by Google. Google proposed to put in place a lasting negotiation framework with a dispute mechanism, a dispute resolution mechanism, and all this framework is monitored currently by a trustee. So that's how our saga was finished for the moment. I hope it was clear.
It was, I think. Thank you very much. Now, I think it would be interesting to compare the French position to the Spanish one. So, Francisco, to the extent that you are authorized to tell us, does the Spanish Competition Authority have a similar position?
Well, in fact, the Spanish Competition Authority doesn't have a position yet because we are actually with the case ongoing. The case is under investigation. We started formal proceedings on March this year, so a decision will be expected for September next year. In case someone wants to know more about the case, I will be more than happy to come back again and explaining it, published details, non-confidential details, but up to now everything is confidential. Only I think I can refer to the press note that was issued with the initiation of the proceedings, where we can see that we currently have the same law. I mean, this earlier regime I spoke about ended in 2021. It was from 2015 to 2021, where the Spanish, the Spanish part of the directive was transposed into copyright law. So we are handling more similar neighboring rights that we could have handled before this transposition took place. And as you can see in the press release, we are investigating Google for a possible abuse of dominant position for the imposition of negotiation of unfair conditions upon the negotiation of contracts with publishers, and a possible infringement of Article 3 of the Spanish competition law that refers to unfair competition practices that can affect public interest because of the distortion of competition because. That's all I'm authorized to say about it.
Oh, thank you for these other precisions. To sum up, on the first area, I wonder if, according to all these precisions, we should deduce that to be effective, this new neighboring right needs the help of competition law to be effective. What do you think about it?
Well, I believe the case I presented, it's a good example because with the first decision, we obliged Google to sit to the negotiating table. With the second, we obliged Google to propose better conditions during this negotiation. And with the third, we put in place a lasting negotiation framework. And also it's important to recall that this ancillary right is not only for Google, but it's also Meta, Microsoft, Twitter, TikTok. So these kind of cases give an example and a clear message to the market on the need to implement and to remunerate ancillary rights.
Indeed, I totally completely agree with Irene. This is only an example of how competition law can help in a particular right or in a particular IP right. I can also We can also recall the Meta case in Italy that is not involving neighboring rights or not involving press publisher rights, but actually involving copyright of music. I mean, it's completely different. But here, actually, it's been enforced also under competition law in a case ongoing where we have adopted provisional measures, and the court has just confirmed that some weeks ago. So we see that not only in this particular case, that could be a specific case, but also in all those cases where and the industry handling the rights is very atomized or very spread, and we have several actors that have this dominant position in the markets. I think competition, I don't know if the most effective, but it's a good resource to handle these issues here. Indeed.
Thank you to both of you for your explanations and precisions. I propose to deal with now with the second areas of about the second area of the roundtable, which is dedicated to spare parts between intellectual property law and competition law. Over the past 20 years, we've heard a lot about spare parts and their protection by intellectual property in a lot of state members in the European Union. In order to regulate competition, intellectual property has come to protect the appearance of parts of complex products. However, with a view to liberalizing the spare parts repair market, the European Union introduced a repair clause in the 1998 directive, I think. And the aim of this clause is to reduce intellectual property in order to balance interests. The role of competition in this progress should also be mentioned, I guess. In 2012, for example, the French Competition Authority published an opinion encouraging an effective implementation of repair clause. To expose this second topic, we have to explain first, I think, what is the repair clause. But at first, it's also necessary to explain the relation between spare parts and complex products. So, Vicente, could you explain this link at first, and then what is the repair clause, please?
Okay. Thank you very much, Anais. First of all, let me thank the organizers for the kind invitation to be here and to participate in this amazing event organized between the University of Alicante and the University of Lille. And thanks also for letting me introduce a little bit the topic to our students, because as far as I know, they are learning now a lot about patents, but they haven't studied in depth designs or aesthetic creations. Well, our Spanish regulation, our Ley de Diseño Industrial of 2003, following the European legislation, defined in its Article 1 what is a design, what is a product, and what is a complex product. It defines a complex product as a product which is composed of multiple components which can be replaced, permitting disassembly and reassembly of the product. So, for example, a bicycle is an example of a complex product. A bicycle saddle, un sillín, or bicycle brakes are components, parts of a complex product. All of them, the bicycle saddle, or the bicycle brakes, can be protected under the Spanish law and also under the European law if they met the legal requirements, novelty, and individual character. And also regarding the component part, it should be visible during the normal use one has been incorporated into the complex product. So under these circumstances, they could benefit from the design legal protection. If, for example, the bicycle brakes are broken, you can buy a new bike, a new bicycle, or what is more common and more sustainable, you can repair them. And here is where you replace the component part of a complex product with some spare parts. So here is the link between spare parts and complex product. And this is applicable to many other industries, but the most important one, as you will see, I guess, during this round table, is the car industry. The problem regarding spare parts is that there is, as Anais mentioned before, an unbalanced situation between intellectual property right and competition law. As you know, IP rights grant a time-specific monopoly to the right holders, and it makes fully sense. Regarding the designs, there is grant a period of exclusivity or blocking of maximum 25 years for allowing the designers to make the intellectual effort profitable. And as a general rule, we should maintain them in a peaceful situation in the name of innovation, which is an essential long-term driver of competition. Anyway, sometimes there are cases where it's necessary to intervene or to alter or to affect this right according to the general interest. In patent law is clear, and probably you have studied some limitations, mandatory license or patent expropriations. And also in design law, sometimes the monopolistic situation could be really harmful to consumers, and I think that spare parts is a great example of this. In this scenario, the monopoly would be too aggressive and too strong according to consumers' welfare, and would generate abusive situations. Imagine, for example, if once you have bought your car, the front glass is broken, and you only have one option for replacing it, going to the car manufacturer. Well, obviously, in this scenario, you will pay more than in a competitive market, and what is worse, you are going to pay more twice. One, when you are buying the car, and second, repairing it. So regarding aftermarket parts is where we've got actually the main debate. It makes sense to maintain the right for original equipment parts. We should guarantee the car manufacturers to get profit of their designs on the primary market, but keeping the right in the spare market would generate abusive and an unbalanced situation. And for solving this problem, according to the general interest and also for the market interest itself, was introduced the repair clause, which is essential and doesn't imply a big disadvantage to the car manufacturer as long as they can compete in a better position thanks to or due to the trademark reputation. So what competition will do through this clause is to adjust the prices in favor of consumers. Not only when they are buying the spare cars, but also indirectly, for example, due to the impact of this clause according to the car insurance prices. And now probably some of you are wondering, okay, but what is the repair clause? What is the content of this clause? Well, this clause is an exemption to the general regime for protecting the design of component part of a complex product when someone used the protected design with the aim to repair the product. It was introduced in Spain in our third transitional provision, our disposición adicional tercera, in our national design regulation, and it's similar to the transitional provision established in Article 110 of the Community Design Regulation. This provision declares, and I'm going to read it because I'd like to be as accurate as possible, that the rights granted to the design right holder may not be exercised to prevent the use of component designs of a complex product when a. the product into which the design has been incorporated is a component of a complex product on whose appearance the protected design depends, and b. the purpose of such use is to allow the repair of the complex product to restore its original appearance. So, for example, if some original parts of my cars, let's think glazing parts, are broken, I can buy some identical spare parts or aftermarket parts in car glass. I think that in France also you've got car glass. And this act doesn't imply a design infringement, despite the designs are registered in the Spanish Patent and Trademark Office. And this is because it's under the scope of the repairing clause. But it's important to remark, to highlight that any use of a component of a complex product for decorative purposes, for example, if you want to customizing or tanning your car for aesthetic reasons, is excluded. So this clause only plays when the aim is to restore the car to its original appearance.
Fine, thank you, Vicente. Natalia, are you with us?
Yes, I'm here.
Yes. I have another question, but I think Vicente began to bring some arguments about it. The question is the following. What could we precise about the social and economical background about repair clause?
Well, I think Vicente said a lot about this, and I will just add a few touches about it. One of the important things we have to understand in this panel is that we have a very different situation here compared to what we have in neighboring rights, where a new right was created, and competition law and competition enforcement policy helps enforce actually this right. In the context of spare parts, we have a different situation in which, based on competition law arguments, on economic arguments, we are liberalizing, which means lessening IP protection for a specific object, so parts of pieces of complex products. And as Vicente said, the main topic, this topic exists especially in the automotive cars, in the vehicle industry, in the automotive industry. What I would add is concerning economic and social elements under this issue is that, as you said, there were many concerns about price deviation and high prices for consumers and high insurance policies because of the existence of an IP right on spare parts. But some other arguments were saying that the price increase was only 5 to 10%. This was an argument against the argument brought by those who wanted to liberalize those rights. Another argument, of course, that was brought also by car manufacturers was that they could, by protecting through design law, they could also maintain a safety level for those spare parts, something that will not be, as they said, something that would not be insured if the market is totally liberalized. There were also some other important arguments, such as sustainability, as Anaïs and Vicente said, and jobs, the creation of jobs in the automotive industry was very often raised also by those who were in favor of more protection, so against the repair clause. And why I bring also those arguments, because in France, the repair clause was just recently introduced, and there were debates for more than 20 years over whether to introduce it or not. I should probably just add that at the EU level there are other competition-oriented regulation related to this area, such as the motor vehicle block exemption regulation, which does not relate to IP, but which helps regulating the aftermarket, the relationship between car manufacturers and garages or car dealers. And also many of, interestingly, several of the important Court of Justice decisions on the application of the principle of exhaustion in design law were based on spare parts cases. This is also important to note. I think I'm done.
Thank you, Natalia. Vicente, do you want to add something?
No, I understand that it makes all the sense. France adopted the repair clause just recently. In Spain, we did it from the early beginning, just more or less in parallel with the directive. When the directive was approved in 1998, they leave on the early question regarding the regulation of spare parts, because were many interests on play, and because of that, even the same directive, the recital 19, declared or mentioned that an harmonized answer cannot be given at that time. From one side, we had some big companies, or to be accurate, countries with big industries regarding cars, like Germany, Czech Republic, and of course France. And from the other side, we had spare parts producers and distributors. In Spain, we used to have an important industry about spare parts, but I think that nowadays Italy is on the top, is in the pole position. As far as I know from the case law, many cases involve Vacaccia, which is an Italian big company. So the directive in this situation established in Article 14, was mentioned the Freeze Plus clause, allowing the members to modify the legal regime if the main aim was to liberalize or to open a little bit the market. We did it 20 years ago, and I think that the Spanish choice was right, according that now this regulation is going to be in the core of the forthcoming design package.
Yeah, thank you, Vicente.
Yeah, well,
as you just mentioned it, you were right. 2 years ago in France, there was finally a new legislation on spare parts, introducing the repair clause, which had been waited for a very long time in France, I think so. And as far as Spain is concerned, Vicente, the situation, as I just understood it, the situation was not perfectly the same, since the repair clause has been received in 20 years ago in Spain. So, Natalia and Vicente, could you please explain us more precisely how this repair clause has been introduced by each legislation in Spain and in France, please?
Okay.
Yeah.
Me first?
If you like.
Okay. Yeah, no, in Spain, as I was saying, it was introduced just from the early beginning, and it's quite similar to the Article 110 of the directive, and doesn't exist a big debate about it. Even the case law in Spain has been applying this clause consistently. We had a case from the Commercial Court of Alicante, which is our court of community design infringement, that remind the requirements for being protected under the repair clause. Our position is also harmonized with the one adopted by the European Union Court of Justice in 2017. So I think that we are quite aligned with the forthcoming position from the early beginning. And makes sense because Spain is not a powder regarding car industry. And because of that, maybe France or Germany, that approved the law 2 years ago, they need more time to do it.
Maybe Natalia has a point of view about it, comparing with the introduction in France. Excuse me.
Yeah, sorry. No, I don't have a point of view, but I have a chronology. Well, indeed, as you said, the whole situation in France evolved and was preparing this repair clause for many, many years. There were many legislative attempts and, of course, lots of battles in courts. So, just to make it clear again, in France, the repair clause based on the regulations for the registered community right will be applied, but in terms of national legislation, so the one that was implementing the directive, for many, many years, until actually this year, spare parts, visible spare parts, could be protected by design law, by protected design, by registered design, but also by copyright. And this is also another element special element of the French system, where, it was quite a stronghold actually for spare parts protection. So in 2012, as you said, the competition authority issued a very, very, very argumented opinion of 200 pages, I think, in which there were many aspects that were explored, and they recommended to progressively open spare parts in the automobile sector, to progressively open it to competition. Then in 2018, the government made a proposal, and actually it passed into legislative piece, but this legislation was discarded by the Constitutional Council because it was not adopted in a formally legal way. And only in 2021, so 2 years ago, the Loi Climat, so actually a law which was on on sustainability and climate protection, in this law, an article introduced a repair clause. But now, what is different from the repair clause that exists in the regulation and that will probably be adopted in the directive in the upcoming years? The difference with the French-style repair clause now is that we speak about must-match spare parts, so the ones that Vicente said that are necessary only for reparation after a car was broken, not those that someone wants to buy for aesthetic purposes, for tuning, for instance. So we take into account only those must-match spare parts. And there, the French legislator makes a difference between original equipment manufacturers, so the manufacturers that that manufacture spare parts that will be placed on the original car, and independent equipment manufacturers, so independent spare parts makers. So the first ones, the OEM, that's sometimes called original equipment makers, OEM, gain the right to sell old spare parts, so they get a defense against a possible action and infringement. They can't be. They have a full exception for those parts. The second group, so independent parts makers, they have to wait 10 years until the protection period for spare parts is finishes. So for this second group of independent part makers, there is it's a defense, but it's a defense that is related to 10 years duration of the design right. And finally, for both groups, the OEM and independent part creators, for them, they can sell and do anything in commerce with a specific type of parts, the window part. So now all parts producers can do whatever they want with window parts only. So this is the scheme where you have to not only understand that there is a defense that is a defense, so it's such like an exemption, like a limitation for specific groups, but also in terms of specific parts of the vehicle. It's very differentiated as such. In terms of copyright, those spare parts are not protected by copyright if they are used for the purposes of repair. So this is the system that exists now in France, and obviously we'll see what will change when the directive will be adopted, but I give you the floor.
Fine. You can go on if you like about the future with the directive and the act from November 2022.
November?
Yeah.
Yeah. Well, the proposed directive, what has been proposed now by the Commission and now has been discussed already in the Jury Commission in the Parliament and by the Council. Obviously, one of the aims of the proposal that comes now is to complete the single market in the repair spare parts. So a repair clause will be introduced in the directive almost for sure. This is the first point we'll have to remember also because such first proposal arrived in 2004. There was a directive that was proposed to introduce such a repair clause, but it was withdrawn in 2014 because some countries didn't agree with it. So now we have on the table a proposal of the directive that liberalizes, will introduce a repair clause in all the member states, and actually that will have the same logic and the same labeling as the one Vicente presented you. so the one that is introduced in the regulation. So if I understand well, it's the same in the Spanish law, but it's completely different from what it is in the French law. Another maybe interesting aspect that was discussed in the options that were proposed that were discussed by the Commission with all the stakeholders is to understand when to introduce this repair clause, whether it has to apply to all designs that are now already registered and also the future designs. So it would have, one of the options was to introduce a retroactive effect to the repair clause. The other option was to introduce such a repair clause only for the future and to keep all those designs that are now registered in protection. So basically there would be 25 years, maximum of 25 years of protection for those designs that would be registered just before, at the moment of the, that would be presented in the directive, but usually it's at the date of entry into force of the directive or at the date of implementation. And the final option, the one that was now selected, is to introduce full liberalization for future designs, but to introduce a transition period of 10 years for those designs that currently exist. And this is the option that was selected by the Commission, that seems to be supported by the Council. And during discussions in the jury committee at the Parliament, some parliamentaries were saying that we don't need a transitional period. Some proposed to reduce it to 3 years, and some, to keep 10. I don't know what was the final result and what the plenary assembly will say, but this is a topic that we, that now can be followed almost live.
Thanks a lot, Natalia. What you just said was very, very interesting, and I noticed that Vicente was agreeing what you were saying. Maybe he wants to react.
Yeah, no, regarding the transition period, I think that is really questionable. If the European Commission said that there was no broad economic justification to maintain this overprotection, and if now we are moving not only talking about competition law, but only talking about sustainability, if through the Green Deal we are adopting new measures in order to guarantee the right to repair and in order to maintain or to impose a duty to the sellers to maintain the spare parts more time for facilitating repairing, doesn't make sense at the same time blocking or impeding what is unstoppable, that is the repair clause. So 3 years, I think that could be more reasonable than the 10 years that is complex to understand.
So future would say if it will. The time is running, and I think we have to close this round table. Are there any questions about the subjects? Or we keep it for later, or for tonight? In the evening, I mean. If any question, I'd like to thank very much Irene, Natalia, Francisco, and Vicente. It was a pleasure to moderate this round table. Thank you very much.
Thank you.
We are going to continue. Good afternoon. First of all, I would like to thank the directors of this course, Professors Edith Blerick-Clement and Caroline Legofil of the University of Lille, Esperanza Gallego, Nuria Fernández and Pilar Montero of the University of Alicante, and the Department of Commercial Law of the University of Alicante for the opportunity to participate in this international seminar about intellectual property in Europe. Let's continue with the second round table, health and environment. They are going to intervene Professors Eric Segregard and Pilar Iniguez. Let me to explain a short bio for each one. Professor Eric Segregard is a professor at the University of Lille. He is Doctor of Pharmacy and Doctor of Law and holds the Certificate of Aptitude for the Profession Lawyer and Diploma in Patents for the Center for International Intellectual Property Studies in Strasbourg. He has 25 years of experience in the intellectual property profession and has worked in the intellectual property service of the Macopharma pharmaceutical laboratory in the firm Egypt and the law firm Veron and Associates. Thank you very much, Professor Eric, for being here today. And the Professor Eric has the floor.
Hello, can you hear me? I mentioned that for some reason I cannot share my screen with Zoom. I use Teams every day and I can share my screen with Teams, but with Zoom, I don't know. Maybe I have some issues with preferences. I will try to share my screen, but I think it does not work. So can anyone share the slides for me?
Yes. When you want, Professor Eric?
Yeah, that's good. Thanks a lot. So I see it as well. I'm sorry about that. So I can start, huh?
Yes.
Okay. Hello, everyone. It's very nice to talk to you. I don't see my screen anymore. I don't see my slides anymore. If you can keep it so I can see what you see. Yes, if you can keep the screen like this, it's better for me. So if we can go to slide 2. To talk about the IP in Europe and about the fact that we have same rules but different practices. If we can go to the next slide. Yes, thanks. I will start with some background information on patents to focus then on the challenges related to patent for the pharmaceutical industry. And when I speak about challenges, I speak about the lack of harmonization. And then the second part will be exactly the same table of content, but for SPC, which is the second main topics for the pharmaceutical companies. And I will give some element of conclusion about the fact that UPC, that we will be discussed also tomorrow during the conference, could be a solution maybe to have a better system for practitioners in the pharmaceutical world. If we can go to the next slide. So you all know this about the novelty criteria. There are some criteria I will just discuss about novelty and inventive step, but there are some others like sufficiency of disclosures, which is also a big obstacle for the pharmaceutical company to get pharmaceutical patents. But so as you know, a patent, an invention is new. If it's not part of the state of the art, and the state of the art could be comprised on any type of documents, a written or oral description, a use. And so when you file a patent application, then we look back what exists already, and you have to be new compared to what exists. So this criteria is not so subjective. The next slide about invented step, then this one is more objective, and we will see that there are some big discrepancies between the trends in the different member states in Europe, and maybe we can also include the European Patent Office. And so, yeah, the invented step is that an invention should be considered as involving an invented step if, as regard to the state of the art, again, this invention is not obvious for a skilled person in the art. So it's very subjective because we have to define first who is the person skilled in the art, what knowledge he has, and it depends on the field. The more a field is complex, the more clever we could say a person skilled in the art will be. And so the obviousness is also very subjective. And so we can see in the next slide that I will go, yeah, you can go to the next slide, yes. Yes, this one. I will start to show you, I hope it's not too, it's readable. So you can see at the top the infringement win rate. So it's for you to know and to see some trends that correspond to the reality. It was a study some years ago, but we still have the same kind of discrepancies. And here, because it's not so clear in the graph, but if you focus at the top, so it's the first infringement win rate. So it's the win rate of the patentee when he sues someone for infringement. And in first instance, you can see in life sciences, so let's say pharma, a very big difference between, let's forget about US and China, even if we see some big differences there. Let's focus on Germany and France. You can see that Germany is at 80% win rate for the patentee, while France is only at 33%. So you have a 47% difference. It's huge. And what can be noticed is that if you look now down to the appeal win rate, so it's the win rate of the patentee in infringement before a court of appeal, you can see that the gap between France and Germany decreased, because actually you have 47%. You have 42% of victory in France. For 17 in Germany. So actually, Germany appeal rate is lower compared to the first instance. And so you can see that between countries and also between level of jurisdiction, you have some differences. And in the next slide, the same kind of graph, but to show this time, if we can go to the next slide, the revocation rate. Yes. And so here, let's focus on the red part. The red part shows you, by country, in life sciences, the percentage of patents that have been revoked. So they are granted. It's post-grant. It's when a patent is attacked for invalidity after, no, you can go back to the slide before. Yes, and so you can see very big differences. Let's forget about India. You can see that the revocation rate in pharma in India is really huge. But you can see in Europe, so if you focus on Germany, 56% of revocation rate for Germany, 48% for France, 39 for Netherlands, and 35 for EPO. So this is at the top for first instance. And in appeal, you can see that while the revocation rate in France decreased in appeal, -5, it's a bit less dramatic. It's the same level in Germany, and on the contrary, the EPO, Board of Appeal, has a very high revocation rate, because we will see it again a bit later. The Court of Appeal of EPO are more strict, are less patentee friendly than the first instance. If we can go to next slide. Yes, about the criteria to invalidate patents. So we take into account all the criteria when they partially or totally invalidate a patent. And you can see that in Germany, in France, and in Netherlands, the most important criteria to kill patents or to refuse to grant patents is invented step by far, the orange part. So it's the main obstacle, while the first line shows the EPO trend, and you can see that invented step, it's more evenly distributed between the different criteria, and invented step represent only 50% of the cases where the patent is refused for lack of invented step. Next slide, please. And I go back to the trend that I told you about. If you still focus on the red part, which is the revocation rate, and more precisely here, not the revocation rate at the patent level, it's more when novelty is not satisfied and invented step is not satisfied. You can see that before the first instance opposition in EPO, you have 12% of novelty which is not satisfied, when before the technical board of appeal it's 30%. And for invented step, it's the same kind of difference. You have 19% invented step not satisfied when discussed in first instance, and you have a huge 42 when it's an appeal. So what does it tell you? It tells you that if you have a pharma client, you have to tell him that if he tried to kill a patent in first instance in opposition and did not succeed because the patent was maintained, he has to file an appeal, because he has a lot of chance to kill this patent in appeal, because again, the technical board of appeal are by far less patentee friendly. Next slide, please. Some other differences is about the duration of first instance proceeding. Here you have just Portugal in Europe, 15%, and you can compare that to the 26 months in average to get a first decision on the merits in the US, and 40 in Mexico. And in the next slide, you will see that for France, when you don't have any incident, on the left, the median duration to get a first instance decision is 26, like in the US. But in the middle, you see that it goes more than 40 months if you have an incident. And then, of course, if you have, it's in French, sorry, on the right, un sursis à statuer, so it's a stay waiting another decision. The judge has to stay waiting that an opposition division decided on the validity of the patent, for example, then the duration could go to 50 months. So it's a lot. And this is something that UPC, we will come back to this at the conclusion, could really improve. It's the duration that you need to have as a practitioner in pharma, but in other fields as well. But because the cases in pharma are quite complex, the duration of first instance and appeal are very long, and you can wait 1.5 years to get a first instance decision, and an additional 2 years to get an appeal decision. We can go to next slide. Yeah, and you can make appear, click a second time to make the right part appearing at the same time. If you can click on the next, I think the right column will appear. Again, yes, sorry. Again, make everything available. Yes, stop. Thanks a lot. Here is the European patent granting procedure. So on the left is what exists. It's the European patent as we know it. You file one patent application, you have one search report. By EPO, you have one examination. And when the European Patent Office says this patent could be granted, it does not become a unique patent, as you know, but several national patents granted. And on the right, what we finally succeed to make on 1st June this year, the unitary patent, it will be exactly the same, but then you will have a unique title, a unique patent for the concerned member states. And we have 17 countries that have ratified the UPC agreement and the unitary patent agreement for now. Then we go to next slide to see the consequences. So, as I said, EP patents, several national patents. On the right, a unique patent. On the left, 38 countries, because you have also, additionally to EU, Switzerland, Turkey, and then for the rest, for the moment, the number of states that have ratified are 17. The EP patent, you have the list to designate countries, so you can say, no, I don't want the 38 countries, I only want the 7 or 8 biggest for my market. And for unitary patent, you have no choice, it's nothing or all the countries. And in the next slide, you will see the main consequences of the unitary patent. First, the cost for translation, that will be decreased. It's too much detail to really explain everything, but you will have less translation than with the European patent. The national annual fees that you pay will be centralized and will be less as well, so that's a positive note. And of course, the big positive note is the fact that now, so far, if you have a competitor that infringes your patent in 4 countries in Europe, you have potentially to file 4 actions to have a decision in your favor, and so with the UPC, you will have to sue before UPC court somewhere in Europe, and you will have an impact on the decision on all the concerned countries. So that's what change for patent made. Another good example of the lack of harmonization. It's a bit technical issue, but I will try to explain it simply. So it's when you are a generic manufacturer and you have a princeps molecule that contain several indications. It was the famous case pregabalin, and so you have 2 indications, the generalized anxiety disorder and the epilepsy, that was at one moment not protected anymore because the first patent on pregabalin expired, but then another patent filed after still protect the third indication, which was about neuropathic pain. And so then the generic manufacturers have obtained some marketing authorization containing what we call a skinny label, because you only mention the unprotected indication, and so you delete the indication that it's still protected. And so you inform the pharmacists, the prescribers, that indeed your generic should not be used for the still protected indication. And even if you do this, there was a dispute, because in this case, everyone, the healthcare professionals, knew that the generic version of pregabalin were completely identical, and there was the same dosage regimen, for all indication. And so even if the generic manufacturer did his skinny label saying only use it for non-protected indication, it could be that he gives the means to have an indirect infringement by the pharmacist who will deliver the pregabalin for the protected indication. And on the next slide, even if the UK judge says here there is no indirect infringement, he made a conclusion saying that maybe someday we will have a generic manufacturer that could be considered as infringer even in case of a skinny label. And he gave two situations. The first is that imagine that a manufacturer indicates in some studies, some reports or advertisements that the composition of the original drug and the generic version is completely identical, and that the same dosage regimen could be used for all indication, then it could be considered as an incentive to infringe the patent. And the next situation could be that the manufacturer of the generic supplies in sufficient quantities only if it was intended for the therapeutic indication that is still protected, because imagine that the market for the protected therapeutic indication is bigger, and then the production by the generic manufacturer is so big that it's for sure intended for the protected patent. Then it could be that, and this situation is not seen in the same way in all Europe, and it's one of the hot topics that we have in the pharma world these last years, and that is a good idea, a good example, of a lack of harmonization of case law. And if we go to next slide, the uncertainty on this situation will be even bigger due to an appeal decision in the US that will have some impact in Europe as well for the judges. It was about the correct this time, and here the judges considered that there was indirect infringement, even if Teva, the generic manufacturer, did a marketing authorization with a skinny label, removing the indication, only because it's the last paragraph, a physician would recognize that at least a subset of patients with the left ventricle dysfunction, which was the non-protected indication, would be classified also as having congestive heart failure that was the still protected indication. And so just because you have an overlap between the two indications, the one which is protected and the one which is not protected, it could lead a generic manufacturer to again be considered as infringing a patent indirectly, even if it does the job to remove by a skinny label the protected indication. We can go to next slide to start the second big part about SPC, so Supplementary Protection Certificate, as you will see in the next slide. If some of you don't know, the SPC is an opportunity to have 5 more years maximum of protection after the patent expiry, because we take into account the time needed to do the clinical trials, to get the marketing authorization, the price, the reimbursement, and so the time that you can protect with your patent the medicine that you launch is not actually 20 years, of course, but more 7 or 8 years in average. And so this is the reason why we organize this SPC to extend the duration of the protection by the basic patent. Can we go to next slide? Yes, this one is not so relevant. I think will speak too much. I will not insist on this. The duration of SPC is quite okay. It's just to show you how it is calculated, the date of grant of the marketing authorization minus the date of filing of the patent application, minus 5 years. And so it means that the more you have time to get your marketing authorization, the more you can have some additional year of protection with the SPC, but within the limit of 5 years as requested by the EU Commission. We can go to next slide. It's more important for the next slide after. So two big conditions to get an SPC. One is to get a valid marketing authorization, and another one is that the product, so the active ingredient or the association of active ingredient, is protected by a basic patent. And the rule is that you cannot have two SPC on the same active ingredient. So that's the rule, and I will show you that in Europe, one of the rules is really a nightmare for judges and especially for ECJ, who are supposed to try to harmonize the case law in this matter, but I will show you that it's quite difficult. We can go to next slide. Again, sorry. So, first to show that the number of SPC cases in Europe is very big. Every year you have around 50 decisions on SPC, so it's not something that we should consider as nothing. It's really a lot of case law. And in the next slide also, you will see the number of cases by ECJ. So you all know what the role of ECJ is, and in terms of SPC is to try to harmonize and to give guidelines to national jurisdiction to explain how they should interpret some points of view. And you can see that every year ECJ gave and conclude something at least 3 times in average. So you can see that the frequency of the preliminary ruling to ECJ is very important. We can go to next slide.
Excuse me, Professor.
Yes.
Eric, only 5 minutes, please.
Okay, yes.
Thank you.
So I will go directly to the point. So you can see here the number of Article 3A, and this is, it's in light blue. So you can skip, just I explain you here that it's 1/3 of all the discussion, this Article 3A. You can go to next slide. That you have a lot of preliminary ruling. Article 3A, it's the green color, and UK did a lot of preliminary ruling, so it means that the UK judge says, I cannot interpret Article 3A, I ask ECJ to explain and to give me guidelines to know how I should interpret. You can go to next slide. Also an issue is that you need a lot of time, in average 17 months to get this preliminary ruling. So you have to wait 17 months to have the guidelines, and then the judge has and needs also 1.5 years to take the decision in first instance. So you can see how long practitioners should wait sometimes to have a first instance decision. You can go to next slide. Yes, just to show the number of Article 3A, so we can skip this one. And go to next slide. Also, just to win time and to have the time to conclude, it was just to show you that all the countries in Europe are involved in this case law. You can skip. Then here you can see that you have also big differences between the validity rate of SPC between countries. It's quite obvious. I don't have to show. So it's really an issue. We see that we have some big differences, and you can go to the next slide that will show quite the same thing. And based on Article 3A. So Article 3A, I will explain, it's that the product should be protected by the basic patent. It's one of the conditions to get an SPC. It's quite technical, but you can see just that the outcome in France, it's that in 18% of the cases only, Article 3A is considered when discussed as satisfied. And Netherlands is at 11%. And if you compare to Germany, they are at 59%. And you can go to next slide, and I will explain, not in detail, but I will just explain you. I'm sorry, I did not translate the Article 3A, so you can keep this slide just before. Can you go up to the slide? Yes, this one. Actually, just in a nutshell, because I think I close to the end, that to interpret this Article 3A, the UK judges, the judge in France and the judge in Germany do not apply in the same method. And so that's why in Hervé Zartan case, which was one of the most famous ones, UK revoked the SPC. In Germany, it was accepted, and in France, it was accepted in first instance and refused by the appeal court. So it's just a very good illustration of the fact that we have also a big problem with the harmonization. And so as a conclusion for the SPC that we just saw, the EU Commission will have a reaction by providing soon, in the next following months, 2 new regulations. So a first regulation to replace the existing ones and to have a centralized proceeding to grant national SPC. So it will be national SPC because we are in the system of national patents for EP classical patents. But then they will launch a centralized proceeding to get more harmonization. And they will also provide a second new regulation, completely new, for the new unitary SPC, that will be the SPC that will extend the future unitary patent. And so, to come back, and it's my last explanation, to come back about the patent side, will UEC useful to get more harmonization? First, in duration, yes, because they promise to have a first instance decision in 1 year and to have an appeal decision in an additional 1 year, so it will be very quick compared to what happened now. But will we have very soon an harmonization? We can have a doubt, because first there is a transition period for 7 years that could be renewed once. And so people could stay in the whole system with national patent and national jurisdiction competent. And the structure of the UPC, which is, as you know, quite everywhere. You have local divisions quite everywhere. So it will be surprising that you do not have any discrepancy between the decision. And you may have some forum shopping, maybe, because forum shopping is possible with UPC. And so we can be sure that we will not have a complete harmonization of case law, unfortunately, for the pharma field so soon. Thank you. I'm sorry if I speak too much.
Thank you very much, Professor Eric Seregat, for your interesting presentation. The next speaker for this second table is Professor Pilar Iñiguez. She is Professor of Commercial Law at the University of Alicante. Director of the Patent and Digital Innovation Module of the Magister Lucentinus, University of Alicante, belonging to the research group of the Prometeo Excellence Project. She is the author of the more than 50 publications, in particular research work in the field of plant variety protection and biotechnology patents, and she is a regular speaker at numerous national and international seminars and conferences. Professor Pilar Íñiguez, the floor is yours.
Thank you very much, Professor Altea Sensi, for your kind presentation. And first of all, I would like to thank the director of this international seminar, Edith Blair, Caroline Lagofic, Professor Esperanza Gallego, Professor Nuria Fernández, and Professor Pilar Montero. I'm going to speak about a specific topic in IP, is orphan drugs legal perspective. In this slide, there is a general principle that said health is a fundamental human right and is specific in relation with the rare disease. I want to see this slide. And it is very important to understand the topic. Why? Because up to 60 million in people in Europe live with rare diseases. In this photo, what feeling does it provoke? Fear? Strangeness? Grief? Need? Are rare diseases and has a specific regulation in IP. What happened with the rare diseases? Many are genetic origin and have genetic components, and from adverse response to therapeutic intervention of other condition, and the causes are frustratingly elusive in general, because has a part that is completely different. Is patients with rare diseases wait an average for 4 years to obtain a diagnosis, and in the 20% of cases, it takes 10 or more years to obtain the appropriate diagnosis. And what happens? That while the diagnosis time is delayed, the patient doesn't receive any support or treatment, has received some inappropriate treatment, and you see how the illness has worsened. In this case, the rare diseases need an orphan drugs. And orphan drugs thus intended for diagnosis, prevention, or treatment of rare or low prevalence disease are life-threatening of chronically debilitating disease. And what happened in this case? The leading commercial incertitude under normal market condition is the problem. In the qualify for orphan designation, in a medicine must meet a number of criteria. Normally for 4 it must be intended for the treatment, prevention, or diagnosis of diseases in life-threatening or chronically debilitating. The prevalence of the condition in the European Union must be no more than 10,000, or must be unlikely that marketing of the medicine will generate sufficient return to justify investment needed for development. And this is very important to understand the regulation, and no satisfactory methods of diagnosis, prevention, or treatment of the condition concerned can be authorized, or such if the methods exist, the medicine must be significant benefit to those affected by the condition. This is the real problem. And to understand the regulation, in relation with this field of IP and this specific topic in relation with the orphan drugs, it's important that you understand the basic concept. What is the marketing authorization application? It's an application by the European Regulatory Authority for approval to market a medicine within the European Union. The market protection is a period of protection during which a generic cannot be placed on the market. The sponsor is a legal entity responsible for submitting an application for orphan designation to the European Union, and the generic drugs contain the said active substances as the reference medicine, and the generic is marketing after expiry of the data of market protection, And the supplementary protection certificate, as speak before in the last presentation, serves as extension of patent right. The aim to offset the loss of the patent protection of pharmaceutical products that occur due to legislation and clinical trial required prior to obtain regulatory marketing approval. And this is the regulation, this is the legal framework in relation to the orphan legislation. And two regulations or two specific rules. The first is the 100/1 to the European Parliament of the Council and the regulation of 2000, and after is the regulation is the 2017/745, and devised together with the Commission implementing regulation 2021. This is the most important regulation in the European Union in relation to the orphan drug. What happened? Nowadays, at the moment, at the 26th of April of 2023, the Commission adopted a proposal to the new directive and the new regulation will revise and replace the existing general pharmaceutical legislation. The proposed revision to the pharmaceutical legislation will consist in two legislative proposals: a new directive that repeals and replaces the directives S 2001 and Directive 2009 and incorporating relevant parts of the pediatric regulation S 2006. And the new regulation, it is very important, repealing and replaces the regulation in 2004 and repealing and replaces the EU regulation 2000 of orphan medicinal products and repealing and incorporating relevant parts of the pediatric regulation. And this regulation is based on 4 pillars, which include legislative and non-legislative action. 4. In my opinion, are 4 more, but only 4 is included in this legislation. Is ensuring access to affordable medicines for patients and addressing unmet medical needs. Supporting competitiveness, innovation and sustainability in the European Union pharmaceutical industry and developing a high-quality, safe, and effective and greener medicines. Enhance crisis preparedness and response mechanisms, diversify and secure supply chains, addressing medicine shortage, and ensuring a strong European Union voice in the world by promoting by high level of quality, efficacy, and safety standards. And the proposal provides that the basic market exclusivity period for orphan medicines products will be 9 years. Market exclusivity will be extended to 10 years in the orphan medicinal product, where to address a high unmet medicinal need. An additional market exclusivity extension could be granted in certain circumstances in accordance with the following provision: is plus 12 months of market exclusivity in the medicinal product is launched in all European Union member states, and plus 12 months of market exclusivity for each of the first 2 indications on orphan medicinal products, up to additional 2 years total, and therefore the maximum period will be increased to 30 years with the interyears. But it is very important because it's the modification to the new proposal of the directives. Is the market exclusivity will, however, be reduced to 5 years in the use of the activity substances in the medicinal products is well established and related application for market authorization were based in the bibliographic data. The orphan drugs will benefit from the same data protection periods as those established for innovative medicinal products. This will include the potential extension available in relation to innovative products, with the cessation of the extension for additional therapeutic indication, for which on an orphan product will be benefit only in relation to extended market exclusivity periods if applicable. And this legal framework in relation to the orphan drugs or the orphan designation is in line with the industrial strategy for Europe, with the European Green Deal, with the European Beating Cancer Plan, and with European Digital Strategy. And it is very important when I explain the medicinal or the orphan drugs and the regulation, the European Medicines Agency. The European Medicines Agency, EMA, plays a central role in facilitating the development and authorization of medicine for rare diseases, with the term orphan medicines in the medical world. The agency is responsible for reviewing an application for a sponsor for orphan designation, and the application for orphan designation are examined by the EMA Committee for Orphan Medicinal Products. And with proposal of the new directive and the new regulation 2023, increased the EMA in power, and the orphan designation will have an initial validity with period 7 years, which may be extended by the EMA in certain circumstances. And after orphan designation, the European Union offers a range of incentives to encourage the development of designation on orphan medicines. The sponsor who obtain to orphan designation benefit from protocol assistance is a type of scientific advice specific for designated orphan medicines and market exclusivity once the medicine is on the market. Fee reduction, also available depending on the status of the sponsor and the time of the service required. And applicants for the academic sector are eligible to receive free protocol assistance for developing orphan medicines and on 19 June 2020. And it's important because in relation with a specific field of the orphan drugs is the pediatric medicine. As some 16% of designated orphan medicines are intended for pediatric use. A medicine authorized across the European Union with the result of the studies from pediatrics investigation, and the plan included the product information are eligible for extension of the supplementary protection certificate. And it's important why? Because for designated orphan medicines, the incentives is an additional 2 years of market exclusivity. And the market authorization application for designated orphan medicines, it is very important, must be submitted to EMA for assessment through the centralized procedure. And the designated for orphan medicines are eligible for conditional marketing authorization. And in some cases, it's very important too to understand the investigation and to understand the increase in this field of knowledge. In some cases, designated orphan medicines may allow to be administered to patients under compassionate use for a treatment option that allow the use on unauthorized medicine outside a clinical study. At the time of the marketing authorization, the sponsor also needs to submit an application for maintenance of the orphan designation in order to be eligible for the 10 years market exclusivity incentive. And a sponsor may also need to submit of an evaluation of orphan similarity. And it is very important because why? Because the small, medium-sized enterprise has a benefit for further incentive, include administrative and procedural assistance for the agency, small and medium enterprise office, and fee reduction. And inside of the market authorization application, the orphan exclusivity prevents competitors from marketing similar medicines with similar indications during the exclusivity period. Therefore, all companies should change in their an orphan medicine authorized for the proposed indication at the time of the marketing authorization. And is there authorized orphan product, then similarity reports must be submitted by the market authorization application address whether there is a similarity with the authorized product. And the EMA has relation with another international partner, with United States Food and Drug Administration, Japanese Ministry of Health, Labour and Welfare, and the European Organization for Rare Diseases. And in Spain, the reference price system for medicines is the first line that understands in relation with the orphan medicine, change in relation with the previous regulation in the way prices are calculated with the coverage of the same time percentage of the markets were replaced by generic guarantee of supplies, and impose a limit for the selection on a medicine be used that determines the above the reference price. As to regulation is the 2006 and the 2006 and the 2014 three regulation in Spain. Nowadays, the Royal Legislative Decree is 2015, and nowadays is the proposal of 10 of March 2003 and the amended or Royal Decree before I explain. In my conclusion, in relation with this specific topic, and my recommendation, obviously, of how to optimize the best practice review process, I think that a better adjustment of the therapeutic positioning report, specific assessment process, it is necessary. It's accelerated funding assessment, creation, and it is very important to control the orphan drugs and external advisory committee, establish a predictable regulatory framework, specific guidelines for action in accordance with the current health needs, and further support an innovative and competitive industry, and empower patient organization. This is more important because control to the European market authorization by the control to the different agency. The market in this specific topic, it is very complicated and the industry is very specific, and for this reason need a best regulation, a best form to registration these specific orphan drugs, and for this reason it is necessary change the actual regulation, not only the European regulation, instead of the specific Spanish regulation. Thank you very much for your attention.
Thank you very much, Professor Pilar Iñiguez. In the next topic, relation to consideration of environmental imperatives, they are going to intervene Francesco Matina and Ogeli Guetan. Francesco Matina, he is President of Community Plan Variety Office, previously Vice President and Head of the Legal Unit at CPBO, specialist in European Union law from the European College of Parma and intellectual property law from the University of Alicante, Senior Legal Advisor at the European Union Intellectual Property Office, and obviously he is a regular speaker at national and international seminars and conferences. Dear Francesco, are you with us?
Yes. Good evening.
Okay, thank you very much. Dear Francesco, the floor is yours.
I don't know if I have to share or if somebody is putting the slides on the screen for me. I can share, but I'm sharing. Can you see the slide?
Yes.
Okay, so good evening, everyone. My topic has to do with environmental issues in relation to intellectual property right on plant innovation. So plant variety right system, and what is the impact of this specific system on the economy of the European Union and on the environment. I will do this by going through a recent study that we have developed with the EU IPO Observatory in 2022, so it's rather recent. The study can be consulted freely on the website of the CPBO. It's the first in kind of this assessment of an impact of an intellectual property rights system, and it was presented last year during a policy seminar during the French presidency of the European Council. Let's go rather quickly through the structure. However, I left these slides for consultation for afterwards. So the first challenge we faced was to establish a methodology for a kind of an assessment which in fact did not exist before. We had to take into consideration a number of factors in order to measure the impact of an IP right system on the economy on one side and on the environment on the other side. And we did it through a combined and coordinating working group with external counselors and the observatory team. We had a second challenge here in defining the quantitative data that we had to use in order to reach sound conclusions. And obviously the important thing in this kind of study is to choose reliable and objective data. So first of all, we relied on our registered data, but not only on those data, also other sources of data you see in the slide. I will not stay longer on this part. Then we had to define the scope, because differently from other IP domains, here we are talking of plants, and the plant kingdom is very broad, as you can understand. So we could not choose to focus only on agricultural crops, neglecting other crops, and we had to make a choice between agriculture, fruit, vegetable, and ornamentals. And we covered, in fact, the 4 groups, but focusing on the most significant crops in each group, which reflect what we have in our registry. And these are the most important crops for our economy and for human consumption, basically. We had to take into consideration different point of view, and we had to consider not only the breeder perspective, but also the grower perspective. And this was a big challenge, and also in terms of competitiveness of growers and farmers, this was an important focus of our analysis. Now, the first part was focusing on, can we determine what is the impact of an IP rights system such as the CPVR system, which is a regional system like trademarks and design already exist in the EU, taking into consideration the economy of the European Union. And it was done with a kind of an analysis considering what would have been the outcome if we had not had the system in place. Okay? And we came to the conclusion that if we were not had a system like the CPVR system, we would have gather a lower production in all the crop fields, so agriculture, fruits, vegetable, and ornamentals, as you can see, which are summarized in the slide. So minus 6.5% on agriculture and the other sector. In terms of contribution to the economic growth, we could lead to the conclusion that this system provides innovation that is sufficient to feed extra people worldwide and generate additional added value, and also contribute to higher employment rates in EU agriculture and also better remunerated employment. There is also a very clear impact in terms of growth of yield in all the sectors. As you can see, the period was 1995 when the system was established until 2019 in all the crops. And the most significant result you can see on the slide is to be appreciated with vegetable crops and arable crops. And the same, if you consider the increase in yields, which is still nowadays the most important objective of breeding programs, the use of inputs such as chemicals, pesticides, etc. is declining. And this is also due to the fact that breeding programs and breeding aims are designed to decrease the number of these inputs, also due to the imperatives of the EU legislation and the farm-to-fork strategy of the European Union. So you can see clearly the impact in terms of growth on yield per year, observable in all the crops and the subcrops. categories. The distribution of breeding innovation in the European Union is mainly focusing on a number of countries. The top country is the Netherlands, it's not a surprise, followed by Germany and France. Every year they contend the second and the third place. And I can tell you that for 2023, Italy is in the fourth place after Germany, France, and Netherlands. When we look at the size of the community plant variety right holders, it was very enlightening, the fact that the majority of companies are belonging to the category of small and medium-sized enterprises, SMEs, PYMEs, and they hold 60% of all the granted titles from the CPVO. This is a very significant and important data to retain because it provides a picture of the diversity of breeding companies, breeding innovation in the EU, making innovation also in niche species, which would be lost if we would not have these companies investing a lot of money in research and development. There is also a clear contribution to employment, direct employment, but also indirect employment. So the whole food value chain was analyzed to take into consideration the cascade impact that this can generate in terms of employment. And of course, there is also an impact which is positive in terms of turnover and for companies investing in breeding and protecting their varieties with an intellectual property right. Now, when we look at the environment, this was another challenging chapter of the study. Of course, we got imperative, let's say, reasons to focus on environment. It's known to everybody that more and more due to climatic change, there is a necessity for increasing not only quantitatively but also qualitatively the production in agriculture. Not only the climate change but also other crises that we are living with nowadays. And water stress is one of the biggest issues that we face and we will continue facing. As you see on this chart, Spain and Italy and Portugal, they are in dark red for this problem. So a need for climate change adaptation is a matter of urgency for our innovation and for the capacity of our sector to become even more innovative in the next years to come. According to a statistic of the European European Environmental Agency, the increase of 1 centigrade of temperature worldwide will have a tremendous impact on breeding and on farmers in general, especially in the south of Europe, Italy, Greece, Portugal, the south of France and Spain will be and are already severely affected. And this will sum to a loss in terms of 9% of the total value of arable land. And I'm sure you have already started observing this in your countries. So the framework within which we made the environmental assessment clearly is the Commission European Green Deal and the two major implementing strategies, the biodiversity strategy on one side and the farm-to-fork strategy on the other side. Well, we clearly show that there is a clear connection between the threats that we're going to face more and more, the role that IP can play in this setting, and reaching of the Sustainable Development Goals, UN Sustainable Development Goals. And here we try to focus at least on the most significant SDG that we considered when we studied the methodology and the approach, we consider relevant, and that an IP right system like the CPVR system can contribute to address. For example, zero hunger, decent work and economic growth, climate action, life and land. And the conclusion in this respect was that thanks to plant breeding and plant innovation and therefore protected varieties, we can reach a decrease in annual greenhouse gas emissions. We can reduce the use of water for agriculture, which is one of the most critical issues. You need water to make agriculture, and you cannot change that. Without water, you will not have production. And also, you need to safeguard biodiversity and land. So arable land cannot go bigger than what we have today, considering the proportion of arable land with land used for human beings, so big cities, places where we live, and the rest of the land has to be safeguarded. So there is an impact in this respect when we look into breeding programs and breeding efforts to try to breed varieties that satisfy these demands and these needs. Let me jump into the final considerations. If you remember, I started saying that we got different perspectives in our mind, the farmers, the breeders, the SMEs, and we came to the conclusion that definitely innovation can give benefits to the farmers and the growers, and an IP right system which is well balanced, which has into consideration elements that are very specific to the object of this protection, which is a living organism, is plants, can benefit breeders and can allow further research and development. And the fact that in the European Union we rely mostly on small and medium-sized enterprises is something unique, is something important that we have to maintain and keep alive in order to avoid that we may lose research and development, we may lose innovation in this sector. Plant variety can support and can help. Plant variety rights can be a tool, not the only solution to all the problems, of course, but can improve low input agriculture. Through plant innovation, you can achieve resistances, for example, to pests and diseases without having to use external inputs. This may contribute to increase environmental protection. It can also bring higher yields and also adaptation to both biotic and abiotic stresses, drought resistance, and less use of water. In this respect, the legislation has to be innovative-driven to accelerate the transition towards including food chain systems. And in this field, we are debating in the Council, in the Trilogue, in the Council and the European Parliament, two important legislative reforms. One is on the marketing of plant reproductive material, and the other one is on new genomic technique, which is both in the stage of analysis by member state in the Council and by the European Parliament. So, unfortunately, these proposals came a little bit late, therefore I don't expect that they will be finalized before the next election of the European Parliament. And in the row, we expect and we hope that we will have a revision also of the basic regulation, the Community Plant Variety Right regulation in the very near future. Thank you very much for your attention.
Thank you very much for your presentation and for being with us this afternoon. And the last speaker of this second round table is Aurélie Guetin. She is Managing Director of Trademark Novagraph France, Master's degree in Private Law from the Université d'Assas, and then Intellectual Property from the Université de Nantes. She has been an intellectual property consultant, trademarks and designs, and a trademark attorney at the European Union Intellectual Property Office. She is a member of the International Trademark Association, Association of Trademark and Designs Law Practitioners, and International Association for the Protection of Intellectual Property. And she is a regular speaker at national and international seminars and conferences. So, Aurélie, the floor is yours.
Thank you, Professor. Thank you, Pilar, Professor Pilar, for organizing this seminar. Thank you, Professor Caroline Gofic, for having invited me to this seminar. I'm very happy. I will maybe shorten my presentation because I know it's late. It's my job to consider the question of trademark law, and more specifically whether trademark law is adapted to deal with the urgent issue of climate change. In fact, thank you. In fact, the subject may come as a surprise. It's more delicate to make the link between trademark law and the climate emergency than between patent law and climate emergency. Indeed, in a very prosaic way, we can legitimately say that the rule of patent law can encourage through the protection of innovation and more particularly green technology to be part of this logic against climate change. What's more, it's essential to control patent laws so that it does not itself become a problem. Do these questions arise in trademark law? Probably not, or at least not in the same term. Of course, if you do a little search on the internet about brand and sustainable development, sorry, not the good page. You will find that it talks about brands that are committed. It's very fashion to say that we are committed to the change climate. In reality, we are talking about brand owners who are committed to sustainable development. This logic of commitment is twofold. It's possible that we are dealing with brands or rather owners with a real ecological conscience. It's also possible that the logic pursued is more mercantile and that the economic operator is simply thinking to please the consumer. And on these points, the report, we have a report of Capgemini which states that sustainable development concerns influence the purchasing behavior of more than half the population. So it's true that the economic operator try to be very careful in their communication regarding this topic. Beyond this issue, it is the exercise of trademark rights that must also be questioned. Is the trademark right adapted to the climate emergency, and is the implementation of the exclusive right adapted to ecological consideration? It's not a simple topic because it's not the purpose of the trademark law to deal with climate issues. So in what way could trademark rights be proved contrary to ecology? Simply by making it possible to punish behavior that is consistent with sustainable development. We are, of course, thinking of the recycling products that could fall under trademark law despite the exhaustion rule. However, we could see trademark law and more generally its implementation as a means of defending sustainable development. Counterfeiting, which I would describe as dirty, the slavish copying of products from far, sometimes very far away, is an ecological scourge that must be combated. As you can see, also the subject may seem remote at first sight. The fact remains that trademark rights can be considered in the light of the climate emergency. This is what we are going to try to do by looking first at the existence of the trademark rights and then at the exercise of the trademark rights in the face of climate emergency. So, the existence of trademark rights, as I mentioned outset, trademark can be a very good marketing tool for economic operators wishing to promote brand image in line with the environment. Nothing could be simpler than having a distinctive sign that highlights this aspect with verbal or figurative element. We will see an example after. There are many distinctive signs, but unsurprisingly, these signs are punishable under trademark law, even if the applicants are ecologically virtuous economic operators. And how they can be punished, we have two conditions to the validity of trademark. As you may know, distinctiveness and descriptive character. For example, on the basis of the distinctiveness, we can refuse to register. I don't see the screen, so yeah. To register a trademark such as "Our planet matters," "Our planet matter," or "Save our Earth now." The sign have been refused on the basis of the Article 7(1)(b) of the European Union Trademark Regulation. The message conveyed by the sign applied for is unambiguous, evident, and instantaneous. When used in connection with a good claim, the slogan is a banal one, not original, imaginative, or fanciful, but is rather banal and would thus be perceived merely as a simple promotional indication. So the sign is not refused because of climate consideration, it's refused because it's not distinctive, but then it becomes a way to avoid any trademark which are not what we would say which do not vehicle the good message. Other example of trademark which were refused: Eco-Perfect, Eco-D'Or, or Green World, green referring to an ecological character. So these trademarks were refused on the basis of the lack of distinctiveness. It should be noted, however, that it's possible to overcome this pitfall and that there are many marks in the register which, despite everything, have a laudatory aspect. We can find a lot of examples, notably in the decision mentioned here. I will show other trademark. The trademark Biolatte. The use of the word element bio as a prefix has no acquired highly evocative scope, which may possibly be perceived differently depending on the products offered for sale to which it's attached, but which generally refers to the idea of respect for the environment, the use of natural materials, and even ecological manufacturing processes. So it's very important, and the element bio is really, really strictly examined by the office. I think maybe you knew the trademark bio for yogurt, and it has been cancelled and replaced by Activia. We have other example, bioplant fluid own production. So this trademark has been also refused, even with the figurative element, because of the presence of the element bio. For class 3, so cosmetic and skin and body care products, and class 5, pharmaceutical and health products. So we have also bio-organic, bio-beauté. However, the value of trademark does not end there, and as it also helps to combat, to fight against greenwashing. Greenwashing is defined as a marketing method that consists of communication to the public using ecological arguments. The aim of greenwashing is to give an eco-responsible image that in no way corresponds to reality. Trademark law can prevent economic operators from registering anything and everything, especially trademark that could mislead consumer. We are referring to disappointed brands. In the French law, it's Article 7112.8. A trademark of such a nature as to deceive the public, in particular as to the nature, quality, or geographical origin of the products or service. So it will mislead the consumer. So this article may help to refuse trademark that we can qualify of greenwashing. However, in order to be able to rely on this ground for refusal or nullity, it's necessary to examine the conditions of application, or rather the assessment of deceptiveness. On this point, it's interesting and maybe, if not important, to look at the examination guidelines of both the INPI and the EU-IPO. With a view to protecting consumers, the INPI will refuse to register all applications related to trademarks that are likely to influence consumers and condition their act of purchase by implying that they possess particular characteristics that they do not in fact possess. And it's just the risk. The term misleading means that it's possible to establish the existence of actual deception or a sufficiently serious risk of deception of the consumer. And the assessment is limited to the date of filing and to the goods and services listed in the application for registration. So the politic or the guidelines of the INPA are very rigorous in these assessments of deceptiveness. In case of any doubt, the examiner does not hesitate to notify and reject the application. Whereas the EU-IPO, the approach is more to believe that the dupes benefit to the applicant rather than the defendant. For a trademark to be deemed deceptive in examination or invalidity proceedings, there must be a clear contradiction between the sign as filed and the goods and services designated. We have maybe, so for example, we have lacto-free for lactose in class 5. So it has been refused by the EU-IPO because of deceptiveness. So this two position, it's very important to see that it's not the same when you file a trademark in France or at the EU-IPO. Finally, it's also interesting, so I will go after, yeah, it's lacto-free. It's interesting to note that in the judgment of June 22, the General Court of European Union cancelled a decision of the EU IPO Enlarged Board of Appeal, which had declared that the trademark La Irlandesa is invalid on the grounds of misleading use. In so doing, it recalled that the deceptive character of a trademark constitutes both an absolute ground for invalidity under Article 7(1)(g) of the EUMR and a ground for revocation under Article 58(1)(c) of the same regulation. To conclude on the subject of disappointment, I would simply point out that the motif is rarely used, contrary to what might be expected. For example, the word mark bio-insect choker for insecticide had to be cancelled because it was liable to mislead the public, because in fact it was not a product, a bio product. Other reason could be used to support deceptiveness in the fight against greenwashing. Indeed, one could naturally try to apply public order and morality. The idea might be surprising. However, as a reminder, deceptiveness is traditionally linked to the EU PC, to public policy. So I will go a bit faster on this part because it's a bit long, and I think we will go directly to the second part, more concrete, and it's the exercise of trademark rights in the face of the climate emergency. So we can see that trademark law can combat greenwashing with several levers available to penalize brands that are falsely green. However, the fight does not really address the climate emergency. This problem is posed in slightly different terms when it comes to the exercise of the rights. On one hand, and this point is probably less legal than political, it seems crucial to be able to enforce intellectual property rights effectively and, what's more, trademark rights. In other words, it is vital that the fight against counterfeiting, and not just at a French level, is effective. And why is that? For the simple reason that the counterfeiting is in no way eco-responsible. Just think of what goes with counterfeiting. Of course, counterfeiters do not have the ambition to preserve the planet, far from it. Counterfeit products are undoubtedly produced in polluting factories, and the products concerned are obviously likely to be even more polluting than the real thing. We have a French organization called Unifab, which notes, for example, that the mercury content of counterfeit batteries is potentially 5 times higher. Radioactive paints are found in imitation watch. Toys material are toxic, and there are poisonous waste products generated by fake cosmetics, pharmaceutical, and chemicals. The list is by no means exhaustive of the harm that counterfeiting can do to the planet. Added to this, we can think about the transport used to transport counterfeit goods. I had a discussion this week with a responsible of the custom services, and they found almost 300,000 pack of counterfeit products in Paris, coming from China, India. So we can imagine how many planes were used for the transport of these products. It's therefore vital that we become even more effective in the fight against counterfeit. So I forgot to. What's more, we also need to look at how counterfeit products are destroyed, or rather disposed of, which, as I've just said, has an impact on the environment. This question must obviously be considered in the light of the rules governing the enforcement of intellectual property. So we in the Article 46 of the TRIPS agreement. So this article states that goods infringing an intellectual property right must be removed from channels of commerce in such a manner as to avoid causing prejudice to the right holder, or unless this would be contrary to existing constitutional requirements, destroyed. And Article 10, we have the corrective measures without prejudice to any damages to the right holder by reason of the infringement and without compensation of any kind. Member states shall ensure that the competent judicial authorities may order, at the request of the plaintiff, that appropriated measure be taken in respect of goods found to infringe an intellectual property right, and in appropriated case in respect of materials and implementation used primarily in the creation of manufacture of such goods. The most important to retain is the destruction. Destruction is really an important topic. It's in the heart of the mechanism. However, it's not the only solution, because we also think about recycling. That could be an interesting option. This is the solution adopted by the Netherlands, and it can be adopted only if it has no effective effects on the environment, and respect the condition required to ensure that counterfeit products do not enter commercial channels. Another solution would be to make donation. It appears in Chinese, Philippine, and British customs services that they give such products to charity. So it's a bit strange, because giving counterfeit products to people, it must be very controlled, because they are generally poor quality, defective, dangerous, or harmful. So there is a very strict control by the organization to check that it will not cause any pain to the people to which we give these products. I think it's. I will conclude now. So what we can say is that trademark law is not really made to fight against, is not adapted to climate change, but we can find a way to refuse trademark, to fight against counterfeit products, but we have still a lot of work to do to preserve our planet.
Thank you very much. Now we are going to open a brief speaking session. Is there any question? No. So I think that we can continue with the questions during the break. Thank you very much to all the participants of this session. Thank you very much for your attention. I will continue tomorrow in the next session. Thank you very much.
Sorry, now we have a little cocktail outside, okay? And tomorrow